Assalamualaikum warahmatullahi wabarakatuh. Welcome back to our channel FL Studio.
Let's go.
So today we're gonna talk about charitable trust. So what is meant by charitable trust? Charitable trust can be understood as a trust that is made for a purpose, not for a person. And in Malaysia, we doesn't have a specific legislation regarding charitable trust. Therefore, we followed the concept under English common law, and this is in line with the section 3 of the Common Law Act 1956. So now let's see an example of case regarding charitable trust in Malaysia. This can be seen in the case of Ong Boon Heng and others versus Tan Peng Huat and others. So the plaintiff in this case had been appointed as a trustee of a said land on behalf of Chinese society. So on the said land there was a temple that the trustee later claimed for the temple to be counted as charitable trust property, as it was benefit the society there. Held that there was a charitable trust since there is an uniform, continuous and long usage of the land for a religious purpose. So from this case, it can be seen that there must be some few elements that need to be fulfilled in order to constitute charitable trust. So what are those elements? So today, we're going to discuss on those elements, and our group will discuss on the first element, which is the purpose of the charitable trust must be charitable in nature. The word charity itself does not being defined under any English law or Malaysian law. So in a good way, it does not restrict the scope of charity itself. So what constitutes charitable in nature can be derived from many other things, and one of it includes the advancements of education. So the advancements of education also had been recognized in the case of Income Tax Special Purposes Commissioners versus PEMSEL, where in this case the court held that charity in its legal sense comprised 4 principles divisions, and one of it is the advancements of education. So advancements of education can be counted as a charitable trust, but what contribute to advancements of education? So one of the things that can contribute to the advancements of education is a research. So research can be simply understood as an important part that contribute to an education. But it need to be understood that not every research can be counted as charitable trust. So in the case of McGovern, the late J laid down few conditions for the research to be counted as a charitable trust. And the first one is, the subject matter of the research must be a useful object, such as it can be used for scientific matters, like now in our situation, a research regarding a COVID-19 vaccine and so on. So the second one is, knowledge that resulted from the research must be spread to the others so that it will contribute to the third condition, which is it will benefit the other people or the public. So without complying with all the conditions, the research cannot be concluded as a charitable trust. So other than research, what else can contribute to the advancements of education? Check out next.
Moving on, does advancement of education in artistic education be held charitable? Yes, the advancement of artistic education also can be considered as charitable trust if it benefited the public. It can be in the forms of educational theatre and arrangement of music or choir in Royal Choral Society against IRC, as it fits the meaning of public benefit. It discusses about an establishment of a society to form and maintain a choir in order to promote the practice and performance of choral works by way of concert at the Royal Albert Hall. Additionally, Redelius' case succeeds in a claim of charitable trust too. A widow of a composer, Frederick Delius, gave her residuary estate for the advancement of musical works for her late husband. The court held that it was a charitable trust because her husband's artwork is undeniably comprised a high composer value that will not put his career in question. The purpose of the trust was to spread the knowledge and appreciation for Delius' work throughout the world. Therefore, artistic education which benefited public will declare as charitable trust. It depends on the court to determine, and trustee's intention is invalid. The court will appoint expert opinion to value this matter. It was illustrated in the case of Viripinian. The purpose of the charity is to build a museum for artifacts with no artistic and historical value, render it not compatible with the public benefit requirement. Next, how about advancement of education in sport? The literal meaning promotion of sport is not considered as charitable in itself, except if the promotion takes place in school and universities and related activities connected with educational, as long as it will benefit the public. In contrast, harmful sport activities that aren't benefiting the public in the ambit of education will be excluded. In IRC against Macmillan, a trust to provide facilities for football and other sports for pupils at school and universities was held to be charitable. The court emphasized that the concept of education changes over time, so activities that are not formally considered to fall in the category of advancement of education may change and qualify now. It is crucial that the beneficiary must be indicated to the young people who is assumed are still undergoing a process of education and development. It illustrated in Redupri Deed Trust where £5,000 was donated to establish annual chess tournament for young boys under 21 years old. The court held that it was a charitable trust.
From all four heads of charity, the one probably more problematic than others is trust alleged to promote political purpose. A gift which is effectively designed to promote political agenda will not be regarded as being in the advancement of education. A trust for attainment of political objects has always been held invalid, not because it is illegal, but because the court has no means of judging whether a proposed trust will or will not be for the public benefit. On the other hand, a trust with some political elements may be allowed to stand as a charitable trust if it could satisfy the requirements of trust for the advancement of education. For instance, the trust must be to inform and educate the public rather than to influence political attitudes. This can be seen in Re Scowcroft, where in this case, a trust was created for the furtherance of conservative principles and religious and mental improvement, and to keep the said reading room free from intoxicants and dancing. The court held it was charitable. In conclusion, a settlor in charitable trust must satisfy all the requirements before a trust can be enforceable. In this situation, the court have to examine the alleged charity and evaluate its social benefits. It is because the law favors charitable trusts by according them certain privilege, such as advantageous tax status. That's all from us. Thank you.